Hello everyone, I'm Professor Paul Carrier, and what I'd like to do is to provide some background information concerning the materials for Class 10 of Contracts 1. Recall where we were. We spent 7 weeks on formation. We spent 1 week on breach, and in particular, the special case of anticipatory repudiation as a bridge between the gap of formation and damages. Last week, we began the damages or remedies materials, and what we covered was the general goal, which is, when possible, to put the non-breaching party in a position that he, she, or it would have been in had the contract been fully performed. And where that is not possible, to provide some other form of remedy. And so we started with restitution. If other remedies are not available, or for some reason are not ideal, then one party, the non-breacher, is entitled to get the things that he or she provided to the other in the belief that the contract would be fully performed. A good example is a deposit. Another example, building materials in a construction contract. If the contract falls apart for some reason, at least the person should be able to go back to the site and take back his, her, or its building materials. Another one is reliance. If somebody makes an expenditure or does something in reliance on the existence of a contract that it would expect to be performed, then perhaps those reliance costs are reimbursable. And a good example of that would be, for example, an outdoor party where the band was going to come in and you needed a tent. The band never shows up. You rented a tent and you can't get your money back. So the tent rental, which expense was incurred in the belief that the contract for your musicians would have been fully performed, is a reliance damage that could be recoverable. The best is expectation damage, and there are two kinds: general and special. A general expectation damage is the kind that naturally flows from a breach. Good example being if you're buying a good that's worth $700, but you get a sales price of $500. If that contract is not honored, you have damage of $200. So if you were given $200 for a breach, you could take that $200 plus the $500 you didn't have to spend because the contract never went through, and that would allow you to buy a $700 item, and you'd be fully compensated in that regard. Another thing is lost profit on a contract between two parties. If someone's going to bake you a cake and it costs $100 to make and $300 is the charge, if you don't make it, shouldn't you still get the $200 for your lost sale? That would be an example of a general expectation damage, because everyone basically expects for that to flow or follow from a breach. There are special expectation damages, and those are the kind that do not necessarily naturally flow from breach, or at least are not necessarily expected to flow from a breach. Let me see if I can give one good example. You and I have a contract where you're going to give me widgets at a certain good price. If you don't get me those widgets and I cannot find an alternative source, I could get a price value. If I buy an alternative source that's more expensive, I can make you give me the extra cost it took for me to get the alternative source. That would be a perfect form of natural flow, general expectation damages. What if, however, I use your widgets in my product and I have a contract to sell my product abroad, and I'm going to make $1 million profit after all expenses on that product? If you don't get me the widgets in time and I can't find an alternative source, I lose a third-party contract with the people buying my product. And so I lose $1 million profit on that. That is a special damage because it doesn't necessarily naturally flow from a breach. And we're going to learn that there are certain requirements for that. So, we're going to cover requirements to collect damages, particularly with regard to what we call special damages or consequential damages. We're also going to pursue the elements required for liquidated damages. Liquidated damages are those that are anticipated and put into the contract. For example, typically when a party breaches this kind of contract, it always costs us $1,500 of loss. So rather than worry about recalculating every time, we're just going to put in a clause at the time of contracting that $1,500 is what is paid if there's a breach. That liquidated damages clause, that possibility, also has a certain amount or certain elements that need to be met for those kind of clauses or those kind of commitments to be honored. We will talk briefly about exclusion of damages as well. That's an issue that may be covered in a few courses or a few classes of Contracts 1, but it is possible under appropriate circumstances to tell a non-breaching party that you are not going to cover any damages for breach. And as long as everyone knows about it, it makes sense. If I was going to sell you something but I'm not responsible for breach, you would find another supplier perhaps, or you'd pay much, much less based on the risk that you take that you can't get damaged if I don't perform. Okay, so exclusion of damages is possible if done correctly. Let's talk about the requirements for an award of damages that are the kind that do not naturally follow from a breach. We like to call them consequentials, or as expectation damages, the special kind, not the general kind. For example, the loss of profit on a third-party contract, not the two-party contract involved in the breach. First, there has to be some way of calculating the damages with some degree of certainty. And perhaps the best example of that is a new business. If a new business has no profit record and there are no similar businesses that we can use as a model for what should be earned, it's difficult to award lost profits because we simply don't know and we have no context in determining what they would have been had there been no breach. That being the case, maybe these expectation damages are not awardable and we have to look to the other forms such as restitution or reliance. Okay, possibly even equitable damages, but we will cover those the following week. So, element 1 for a damages award when it comes to special damages, consequential damages, expectation damages that are special or consequentials. They must be certain. There must be some way to reasonably calculate what they are. Okay, not something that is a bizarre and tortured valuation. They need to be foreseeable. The breaching party who is asked to pay for these damages should know of their potential or their possibility during the time of contracting. And because the person knows about it, the person should be responsible for it. If a party does not know that a certain kind of special damage may be incurred, he or she doesn't take steps to protect him or herself. And it may not be fair to force the loss on that person. And for example, a good example would be where there's a third-party contract that may cause a great loss in profits, but the breaching party may never expect that. And if he or she did expect that or foresee it, he or she would have charged more in order to buy more insurance or otherwise have a fund to pay for breach and these special or consequential damages because he or she then knows about it. That's the second element, foreseeability. The third one is avoidability. Some jurisdictions call this a duty to mitigate. Florida does not use the terminology duty to mitigate. You are not under a duty as a non-breaching party to lower your damage. However, if you could have lowered your damages acting reasonably and you did not, you probably disqualify yourself for these special expectation damages, these consequential damages. And so, we don't say duty to mitigate, but we say losing certain damages that are possible, but you don't get them because you could have easily avoided them. All right? We will also, with regard to liquidated damages now, what are they? It is a damages calculation that you do before breach that you lock into the contract at the time of contracting. So it operates at time of contracting, and it's a calculation or an estimate of what breaches tend to be. And rather than try to prove how much the damages are going to be or were in each example of breach, you can collect or you can create an estimate up front and place it into the contract. For example, every time somebody doesn't buy the products that they've ordered, it always costs between $900 and $1,000 to have them shipped back and sent to another potential buyer. So you could argue that a liquidated damages clause of $900 to $1,000 for shipping, no matter where, is reasonable because it's easy to calculate and you have a rational basis. You have a logical mechanism for calculating what those damages tend to be. Okay? So you have to be working with, these are the elements now, a reasonable calculation. There's got to be some way of determining what the damages probably would be based on some supportable facts. Second, to ascertain what the damages will be in the future at the time of breach may be difficult. In some cases, it's on the low end. In some cases, it's on the high end. We can bring in all kinds of experts to determine the exact amount every time, but that wastes a lot of time. It costs a lot of extra money with regard to hiring lawyers and even experts to determine what the damages are. And so because they are not readily ascertainable, quickly ascertainable, even at the time of breach, the courts will allow this ability to predict them. Okay? So the reasonable ability to calculate them, not easily ascertainable, which is why the court will allow it at the time of contracting, because it's actually quite difficult and painful to determine in each case what the damages are in the case of actual breach. Okay, and therefore the law will permit an estimate. Third, damages, liquidated damages clauses cannot be punitive, only compensatory. And so if it typically costs $1,000 in case of breach and you charge $5,000, that's clearly a penalty, and contract law does not like penalties. It doesn't like windfalls, it doesn't like penalties or punitive damages. So again, reasonably calculable, some mechanism based in fact. They are not easily ascertainable, which is why the court will in fact allow this kind of prediction or estimate, and they cannot be punitive. They can only be compensatory. Let's call those the three basic elements of liquidated damage. If a request or if a liquidated damage provision in a contract meets those criteria, then a court will probably uphold it, no matter what the actual damages turn out to be. There's maybe a UCC exception to that we'll talk about next week. Okay, so we've covered the requirements of damages, the requirements of damages that are sometimes problematic, and those would be the special kind, the consequential kind. Now, we also covered liquidated damages to a small degree, and with regard to exclusion of damages, we'll talk more about that, but understand that sometimes parties in advance of breach can determine by contract to exclude or even limit the level of damages that are recoverable. And remember one of the basic tenets of contract law, which is that the parties should be free to contract without too much intervention. And so if one party wants to exclude damages for breach, there should be no reason why he, she, or it could not do that, so long as the other side walked into the contract knowingly, realizing that there was an exclusion, and taking steps to protect him, her, or itself by having insurance, by having alternative sources, by lowering the price paid for the risk that there would be no damage if there is a breach. And so we'll cover it at some point during Contracts 1, but there certainly is the possibility to exclude damages as well.